which was served on February 6th, 2019. And the court is aware of that. Now, so let me begin by saying that we all know what the standard is, so I don't need to go into that. Something happened yesterday which was really interesting in terms of what we now know the state's theory is. And it doesn't make any sense. This is what we believe. Based upon the demonstration that was done with Dr. Just and Ms. Ellis, of Ms. Ellis standing like this and then asking Dr. Just whether or not the shots to the arms would have incapacitated him to the extent that he wouldn't really be able to run, and then the shot to the heart would have killed him. I don't know if that's what they're going to argue, but it seems like they're going to argue that the shots to the arms occurred first and the heart shot occurred later. Now, that's apparently what they're arguing, but perhaps they'll argue something different. With regard to the single episode argument that we have, I'm going to basically just stand on the motion, but I did want to highlight the case of Williams versus the state, which is cited at 90 Southern 3rd 931, which talks about both double jeopardy and merger. And in head notes 7 and 8, the court in that case said the principle of merger is an exception to the standard double jeopardy analysis, and but for the merger doctrine, attempted premeditated first-degree murder and attempted felony murder would not violate double jeopardy. And then the last full paragraph before the conclusion reads, based upon this specific fact scenario, where appellant's pursuit of the victim constituted one criminal act or one attempted murder, we hold that although appellant's dual convictions for attempted premeditated first-degree murder and attempted felony murder do not violate double jeopardy under the standard double jeopardy analysis, they are impermissible under the principle of merger. And because it appears based upon the state's demonstration yesterday that we're talking about a single episode, that is why that case is applicable. Now, the second element of my argument, Your Honor, is the state's failure to rebut the prima facie case of self-defense, which is on page 4 and 5 of our written motion for judgment of acquittal as to both counts. And the cases that I'm relying on in that, Your Honor, are the Fowler case, which is cited at 921 Southern 2nd 708, and the Williams case, which is a Florida Supreme Court opinion decided on January 4th, 2019. It's Supreme Court case number SC 16-2170. Now, in those cases, Your Honor, this is what they say. Even though these are appellate cases which deal with the failure to grant a judgment of acquittal. And in Fowler, this stands for the proposition that on page 4, head note 3, we recognize that the question of whether a defendant committed a homicide in justifiable self-defense is ordinarily one for the jury. However, when the state's evidence is legally insufficient to rebut the defendant's testimony establishing self-defense, the court must grant a judgment of acquittal. And it goes on further to talk about a case called Sneed versus State at 580 Southern 2nd 169. And the court said, in Sneed, the court concluded that a motion for judgment of acquittal should have been granted when the state's evidence was legally insufficient to prove guilt beyond a reasonable doubt because the state failed to rebut the defendant's direct testimony that he acted in self-defense, and in fact, some of the state's evidence corroborated defendant's testimony of self-defense. And on page 5, the last full paragraph, similarly, here the court has offered no understandable theory of evidence that contradicts Fowler's explanation of self-defense. In fact, in responding to the motion for judgment of acquittal at the close of the state's case, the prosecutor acknowledged that, quote, there's no indication of a reasoning for this happening, end quote. Fowler presented a prima facie case of self-defense, and the state simply did not carry its burden to rebut this claim of self-defense and to prove Fowler's guilt beyond a reasonable doubt. Therefore, we reverse Fowler's judgment and sentence and remand for discharge. The Williams case, decided on January 4th, 2019 by the Florida Supreme Court, essentially takes the same position. And they reversed on one count and did not reverse on another count. In the discussion section on page 5 of that opinion, down at the bottom, it says, in a case where a defendant alleges self-defense, the state must prove that the defendant did not act in self-defense beyond a reasonable doubt. A trial court must grant a judgment of acquittal when the state's case is legally insufficient to rebut a defendant's prima facie case establishing self-defense. However, a judgment of acquittal should be denied where a jury would reasonably reject the defendant's explanation of self-defense. But evidence that leaves room for two or more inferences of fact, at least one of which is consistent with the defendant's hypothesis of innocence, is not legally sufficient to make a case for a jury. In order to establish a prima facie case of self-defense, the defendant must show that he, 1, was attacked in a place where he had a right to be, 2, was not engaged in any unlawful activity, and 3, reasonably believed it was necessary to use force to prevent death or great bodily harm. And in that case, on one count, the Supreme Court said because Williams presented a prima facie case of self-defense, it was necessary for the state to refute his claim beyond a reasonable doubt. So what's the evidence in this case of self-defense, which all it needs to be is a prima facie case? And they then have to prove beyond a reasonable doubt he did not act in self-defense. The evidence is that, presented through the state's case, that the deceased in this case pointed a handgun at Mr. Raja. Mr. Raja testified through his walkthrough that the gun was pointed at him. Through the evidence that was presented through the light reflectivity test, and also through the evidence through Investigator Wills, it's clear that red glinted off of the gun, whether it was the barrel or the side or whatever. There's no question but that gun was in Mr. Jones's hand, and that red glinted off of it, and the defendant saw that. Whether the gun was pointed directly at him or whether the gun was in his hand, he is justifiably he's justified in using deadly force, and that's the prima facie case of self-defense. And there's no evidence to rebut that, none. May I move on now to the judgment of acquittal on manslaughter? And the cases that I'm going to be using in that are the Tias case, the Penton case, and the Ben case. Now, we're all aware that the jury instruction on manslaughter by culpable negligence includes a paragraph which in essence states that the state has to prove that the defendant's acts or omissions were so reckless that he knew or reasonably should have known that those acts or course of action were likely to cause death or great bodily injury. What are the acts or course of conduct? Driving the wrong way up the ramp. That individually, in and of itself, is not an act that is likely to cause death or great bodily injury. Pulling up close to Mr. Jones's SUV, that in and of itself is not likely to cause death or great bodily injury. Exiting without this vest, that in and of itself is not likely to cause death or great bodily injury. In the light most favorable to the state, which is it needs to be considered at this point in time, the state alleges that Mr. Raja approached Mr. Jones aggressively. So in the light most favorable to the state, does that in and of itself, is that an act that is likely to cause death or great bodily injury? And finally, not identifying himself as a police officer, which is, in the light most favorable to the state, that's their argument. Although yesterday, I think we proved that something was said, and as a matter of fact, by stipulation, the transcript of that recording does say there was a human voice prior to Mr. Jones saying, huh. So not only do none of those acts individually cause anybody to know or should have known that those acts were likely to cause death or great bodily injury, but in combination, they do not. The state has to prove that the defendant's conduct was the legal or proximate cause of the harm at issue. And for that proposition, we cite the case of Albert Tias versus State of Florida, 845 Southern 2nd 318. I'm going to highlight it's it's the end of head note 5. And it says, the two affirmative elements of manslaughter are the killing and a causative link between the death and the act, procurement, or culpable negligence of the defendant. In addition to establishing causation in fact, the state must prove that the defendant's conduct was the legal or proximate cause of the harm at issue. The two questions that must be answered in establishing legal causation are: 1, whether the prohibited result of the defendant's conduct is beyond the scope of any fair assessment of the danger created by the defendant's conduct, and 2, whether it would be otherwise unjust, based on fairness and policy considerations, to hold the defendant criminally responsible for the prohibited result. The Penton case, which is cited at 548 Southern 2nd 273, and head note 2, criminal responsibility for manslaughter should be determined by considering the act that resulted in the death from all the surrounding circumstances. Now, at this point in time, Your Honor, the state has not elected whether they're going by, it does say manslaughter by culpable negligence, but in the jury instruction presented to them, they are going act culpable negligence, and I think at some point in time they're going to have to elect. In the Ben case, B-E-H-N versus state, which is at 621 Southern 2nd 534, head note 1, to support the allegations of culpable negligence contained in the information, the state asserted that Ben ran a red light and that at the time of the accident, Ben was knowingly driving with brakes which were out of adjustment. As we have indicated, the state did in fact prove both of these allegations. We conclude, however, that the conduct complained of did not meet the standard required under the manslaughter statute for culpable negligence. The controlling case law indicates that operation with deficient brakes, even when coupled with a traffic infraction, does not rise to the level of criminality required to support a manslaughter conviction charged under the statute. Further, at the end of footnote 2, just before head note 2, before head note 3, the court cites to another case, Caraway versus Revel at 116 Southern 2nd 16, and it says, the character of negligence necessary to sustain an award of punitive damages must be of a gross and flagrant character, of evincing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or that there is that entire want of care which would raise the presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard of the safety and welfare of the public, or that reckless indifference to the rights of others which is equivalent to an intentional violation of them. Further on, head note 4, applying the above cases to the facts of this particular case, under no view of the evidence would it be proper to convict appellant of manslaughter by culpable negligence. The state failed to prove a course of conduct showing reckless disregard of human life or a conscious indifference to the consequences. Although knowingly operating a truck with bad brakes is negligent, it does not rise to the level of culpable negligence. So in that case, that's a very interesting case, Your Honor, because in that case, the facts are that the defendant knowingly drove with bad brakes. Now, knowingly driving with bad brakes doesn't necessarily mean that it's likely to cause death or great bodily injury, but it's certainly it's closer to that than the acts that are complained of in this case. In addition, Your Honor, there was between the acts complained of and the use of force by Mr. Raja, the evidence is that Mr. Jones pulled a firearm. So there's an act in between the acts complained of by the state and the killing. Let's look at it from the perspective of a non-officer. If a civilian had done what the defendant did, and if Mr. Jones was so afraid that he pulled his gun and pointed it at the defendant, and that is not the standard, his perspective is not the standard, but just assuming that, once he did that, the defendant was justified in defending himself. And now let me move to the judgment of acquittal on the attempted first-degree murder, Your Honor. It is apparently the state's theory that the defendant premeditatedly attempted to kill Mr. Jones after he no longer had the gun. There is zero evidence of that. In fact, the recording, which was agreed to by the state, shows that Mr. Raja fired the last 3 shots after telling Mr. Jones to, quote, drop it, end quote, which means that the only evidence which was put on by the state is that Mr. Jones was armed when he was shot. Thank you.
You're welcome. State, would you like to respond?
Yes, sir. Morning again, Your Honor. Obviously, the state's filed a response to the judgment of acquittal and a memo of law, which was in anticipation. But it does discuss a lot of legal principles and has the case law. I'm really going to focus on the facts here because what Mr. Richardson said in part was absolutely accurate insofar as everything is viewed in the light most favorable to the state. However, it's not just that. Also, the defendant admits every inference and conclusion favorable to the state that a jury might fairly and reasonably draw from the evidence. We're good on both counts, Your Honor. I mean, on the manslaughter, when looking at the actual evidence that's been presented here, irrefutable evidence, we have a defendant who runs the wrong way up an off-ramp at I-95. He parks within several feet of a vehicle, head-to-head. He's in an unmarked van. He makes zero announcement of who he is per the evidence submitted. He has zero indication from his hat to his badge that's in his back pocket to not wearing his vest that he's a law enforcement officer. His conduct when he actually confronts a citizen in need of just assistance, which is confrontational from the start. We have an AT&T recording which lines out everything and has been played many times, and the court's fully aware. There's no need for him to even stop. There's actually, it goes against the whole purpose of his detail that he's working at that time to even stop. He even admits that he knows the orders that he's been given in relation to this detail, and he failed to follow. It's 3 o'clock in the morning, and a vehicle was pulled in the emergency lane of an off-ramp. He has said himself that he went to check it out. There's no suspicion whatsoever of any criminal wrongdoing of anybody in that vehicle or on the part of Corey Jones at the time the defendant approached him and did one thing. He acted reckless. All of this adds up to being reckless, and his statement that he made only makes it worse for him and helps to prove our case. He knows that he's supposed to treat it like a traffic stop. He didn't. He knows he's supposed to wear his tactical vest. He didn't. He knows that he has his badge. He's supposed to announce himself, and he didn't. There's only one reasonable expectation with that type of conduct and the conclusion that's going to be reached when you approach somebody on the side of the road at 3 o'clock in the morning, and that person is going to expect that they're going to get assaulted. And that Corey Jones, yes, there is self-defense in this case. Corey Jones was defending himself. Unfortunately, he didn't have one in the pipe and the safety was on. But he was defending himself from what he saw as being an initially aggressive, and reckless conduct by a person that he had no idea was an officer. There's only one conclusion that he thought was going to happen. Somebody was going to get hurt. Something bad was going to happen. On the attempted first-degree murder, once again, that recording clearly identifies this break. And that's really when we get to the law. We have this break of this conduct. 10 seconds is a long time, especially under the law when we know that premeditation can form in a matter of seconds, and not 10, but a matter of a couple of seconds. This is his chance once again to do the right thing, and he failed to do it. Now he has the specific intent has evolved, and now, in his words, he's aiming. He has one reason to fire that gun 3 times in a very controlled method, much more controlled than when he initially approached Corey Jones. We have evidence that Corey is now running. He is retreating. He doesn't even have the first 3 shots fired out of his gun until Corey is 30-plus feet behind his vehicle. A stranded motorist is now 30 feet plus behind his vehicle, being chased by a man who has no identification on him before 3 shots are even fired. And he makes the decision to continue that. That specific intent now is fully formed. He tells his sergeant on the scene, I saw him throw the silver handgun in the grass behind the SUV. That's not something we made up. That's a man with a 25 career and being in the Marine Corps saying exactly what happened that day, and deposition, stand your ground hearing here today, it's all the same statement. He knew that Corey Jones didn't have that gun. We got 125 feet from that firearm that unfortunately Corey Jones pulled out at some point and where his body was found. And as of right now, we have Dr. Juice saying that he wasn't making it more than a couple yards. They don't like that. Well, guess what? It's the light most favorable to the state, and he's not charged with first-degree murder. He's charged with attempted first-degree murder, not for the shot that definitely happened in the last 3 that took Corey Jones' life, but for the minimum of 2 and the maximum of 3 shots that were fired during that last volley that didn't strike Corey Jones, for which he wanted to strike Corey Jones, for which he wanted to kill Corey Jones, as Corey Jones was running away unarmed. He is the initial aggressor. There are many times we stand up here and say, he is the definition of a term. He's the definition of an initial aggressor. The way that he acted toward Corey Jones at that time, in that place, they don't get self-defense because he's the initial aggressor. That's one of the instructions that we absolutely legally believe that we have a right to, and we've shown through the evidence. We've shown through the casing groups that there's a pursuit of Corey Jones. And counsel stands up and says, well, obviously, Corey Jones still had a gun because you could hear the defendant say, drop the gun. Well, guess what? 33 seconds after Corey Jones was definitely lying on the ground dying, that defendant also said to a 911 operator, drop the effing gun. Corey Jones absolutely didn't have a gun in his hand at that point. So just because a defendant says something, in this case, given the evidence, is completely and wholly irrelevant. There's no legal reason at this time that both charges should not progress forward. We discussed merger, we discussed double jeopardy, we discussed single homicide, Blockburger rules. At this stage, if there is something after a verdict, that there is going to be a discussion.
That's what I wanted to talk,
That is a different time to have that discussion. But as of right now, and even then, so we're 100% crystal clear, we believe that we're good on all of those, even after a verdict. But this is really premature at this stage based on those legal arguments.
That issue, yes. If and when, I'll cross that bridge, if
Yes,
and
sir.
when it comes to, that's exactly how it hit me when I read it. I think it's in the area of DUI manslaughter cases where you see a lot of that after the verdict.
That's-
Then the judge has to eliminate, or the state eliminates one of the charges. And I'm not prejudging it,
understand,
but
sir.
I know if and when that happens, I'll want it a really
We will absolutely-
slow down, brief it, and we will take that. So with all that being said, at this juncture, I deny the defense's motion. Okay. So I think the jurors are here. I can hear them. So my thought is, let's get started with getting them working.
Yes, I have a minute
Yes.
of issues. Mr. Fernandez and I have been talking about photographs this morning that I'm going to use.
Okay.
He objects because certain of them are duplicative, but they're just close. I've done it close-ups and not close-ups to show perspective. I don't know if you want to see them, but I think I need to introduce all of them through my next witness, LaForte. There's no allegation that they're prejudicial or they're irrelevant. He's just saying they're duplicative, but they're all different. In other words, there's a close-up of a ruler and a far away. There's a close-up of a string tied to a pole and a far away. I mean, that's what's going on. So I don't know how.
Let's hear what he says.
It's just cumulative, Your Honor. I mean, I got boxes of thousands of photographs,
Sure.
obviously. We culled it down to a reasonable amount. And even when we got to a reasonable amount, when the defense said, hey, realistically, you got 3 pictures here saying the same thing, I say, you know what? I got a far view, I got a middle view, and a close-up view. I think they're all important. I'll take out one, maybe even 2 of them, because it's all about the cumulative effect. And that's all it is. I'm asking them to take out like 5 or 6 pictures because it really shows their fella with a tape measure. 5 feet away, 3 feet away. It's just a cumulative effect.
All right.
Like we've been talking about this entire trial.
All right, so I take the cumulative argument seriously as evidenced by my prior ruling. However, on this issue, I deny the state's motion, and I'll allow you to put all your pictures in.
Okay.
Okay? Sure.
Thank you, Judge.
You're welcome. All right. I think we're ready. Let's bring in the jury. Oh. All right, everybody have a seat. Jurors, how did we make out? I'm sorry. How'd it go? Everybody was all right? All right, terrific. The one day we actually stayed really late is the day you asked me not to stay late, and it was killing me to do that to you, and I appreciate your patience, all of you. And I have to say, I've picked up, Daniel, you must be a fisherman. Yeah, I could tell. And so when I say in my jury speech, would you rather be golfing, fishing, or hit home for you? Yeah, good. I'm so glad. And I know all of you have lives out there, but I'm just going to keep thanking you because I know how difficult it is. But the important question right now, any issues? Anything happening last night? Everybody was smooth as silk? No problems, nothing I need to know about. All right, I really pause there because I'm telling you, I need to know if anything's going on, anything uncomfortable, I need to know about it. Then I think, and this is just a gut reaction, I didn't even talk to the lawyers about this, but there's something I want to get done in this case today that I know is going to make it a little longer than anticipated. So I think I told you yesterday, well, you might be out of here by lunch, and then we're going to do closings in the morning. I got a feeling we're going to be here a little longer than that today, but we're still planning on tomorrow morning. When you take a seat, the first thing that's going to happen, the state's going to stand up and begin their closing argument. And just to give you the roadmap there, based on the complexity, the seriousness, and the nature of the case, I've given the lawyers a little longer than I normally do for closing argument. And I'm going to read an instruction later to you about this. The state gets to go first. So I think Ms. Ellis is going to go first.
Yes, Your Honor.
And she's going to go for approximately 1 hour. Then the defense gets to go, and I believe Mr. Lubin's going to go for the defense, and he gets 1 shot, and it's 2 hours. Then the state gets last words, 1 hour. And I'm going to pretty much hold the lawyers to that because I've given them more time than I normally would. And so we're going to put a timer on them, and I just want to give you that. I know that seems like a long time, but there's been a lot put out there for you to consider, and I want to give them the courtesy to be able to present their arguments and do it in an orderly fashion and not feel rushed. So I gritted my teeth and I said, okay, I'll give you 2 hours. All right. So with that being said, Mr. Lubin, call your next witness.
Michael LaForte.
Michael LaPorte, please. And Mr. LaPorte, good morning, sir.
Good morning.
Follow Deputy Dunkley out to the middle. And once you get there, if you'd raise your right hand and face Mr. Clerk for us.
Do you solemnly swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Terrific. You're going to have a seat right up here. Watch your step. That chair swivels and it rolls, so you get it where you're happy. And what's very important to me, though, is that that microphone, which moves all the way around both the base and the flexible neck, and get it very close to your mouth and talk into the center of it and tell us your full name and spell it for us.
Michael F. LaForte. It's L-A, capital F-O-R-T-E.
Terrific. Mr. Lubin, you may proceed.
Thank you. And you can actually slide the base of it a little towards you so you don't have to lean forward.
There you go. Perfect.
What is your occupation, Mr. LaForte?
I'm a forensic consultant.
What generally does a forensic consultant do in the broadest sense?
We reconstruct crime scenes, basically shooting scenes.
Okay. What is your background and experience in the area?
I spent almost 30 years with the Jacksonville Sheriff's Office. It was 15 years I was road deputy, and then the last 15 years I was a crime scene detective. I retired in August of 2003, and then in June of 2011, I was hired by Knox & Associates to come to work for them.
Can you generally describe the duties and obligations of a crime scene detective?
Yes, we would respond to crime scenes, any crime scene, and our duties were to document the crime scene with photography, through diagramming, and through the discovery, the collection of physical evidence.
What is the difference between a crime scene detective and a crime scene technician?
Same thing, just depends on which department you work for.
Okay. Would you look for and collect evidence?
Yes.
Why generally do you want to look for and collect evidence?
Well, any crime scene that you go to, you need to find the pieces. Basically, you're looking for a puzzle. You're trying to put a puzzle together to get the best picture possible as to the circumstances that what occurred. And the only way you do that is through the physical evidence. Some physical evidence is readily visible to you. You don't have to do anything other than document and collect it. But a lot of the evidence, sometimes 50% or more, you can't see. So you have to do specific procedures to be able to make it visible both to the human eye, to the camera, and then be able to collect it, preserve it, and then present it at trial if it comes to that.
What would your estimate be on the number of scenes you've examined or you've worked on?
With the sheriff's office, as a crime scene detective, I processed over 9,500 crime scenes, 800, in excess of 800 death scenes, and of that, 500 were homicides.
Let me just ask you generally to be more specific about the types of evidence that one would expect to collect at a scene such as this, a scene involving the death of an individual, just generally.
Generally, if you're talking about shootings, you're talking about firearms, you're talking about fired cartridge cases, fired bullets, blood evidence, trace evidence is a possibility. Again, it just depends on the circumstances.
And were cartridges or fired cartridge cases found at the scene?
Yes,
And were they documented?
yes.
Let me show you what has been marked as. Let me show you what has been marked as Defendant's Exhibit 11. I think the ladies and gentlemen have seen this already, but just, again, I'm not going to show it to them until you identify it. What is this?
This is a diagram of the scene that was done by the Palm Beach County Sheriff's Office.
And from your view of photographs and so forth and so on later on, and all of the work you've done in the case, does it generally appear to be accurate for what it does show?
Yes, sir.
I would offer 11 to evidence.
Any objection?
No, sir.
Admitted.
Okay. I'm going to put it up here. So, can you see it?
Yes, sir.
I see it too.
That's fine. I'm good. Yes, sir.
Can you see it?
Yes.
Okay. So, what do we see generally in this picture?
Start off, we see that the locations of the two vehicles, the van and the SUV.
And I'm just going to take the liberty of pointing to them just so we can orient it.
Yes.
What is this?
This is the van.
And what is this?
That's the black SUV.
And all of this is verified by photos you've reviewed of the scene and so forth, correct?
Yes.
So the van and the SUV.
Yes.
Okay, so what do the numbers 1, 2, and 3 signify?
Those are the locations of the first three fired cartridge cases.
Okay, and what do 4, 5, and 6 signify?
That's the second location of, again, three fired cartridge cases.
Now, generally, and you've done ejection pattern testing before,
Yes.
and you did it in this case.
Yes.
But generally, what do we see with a Glock 27 as to generally in the loose sense of the word, where did the casings go when the gun is fired?
Generally, they are ejected to the right and behind. That's not always where they end up, but initially that's where they go.
So where they end up may not be where they hit,
Correct.
but if you do enough of them, you're going to generally get a pattern of where they go.
Yes, sir.
All right. That means then that as to 1, 2, and 3, in the broadest general sense, because I think that's what you're saying is all you can get, is the broadest general sense.
Yes.
In the broadest general sense, would that mean that the bullets were fired from this general area?
Yes.
Okay. And again, this is not an exact science, but it's a science.
That's correct.
Okay. Now, 4, 5, and 6. In the general sense, does that mean that 4, 5, and 6 would be fired from this general area here?
In that general area, maybe a little bit closer to them, to the cartridge cases.
To the cartridge
Yes.
cases? But in that kind of...
Yes. Yes.
Okay. Now, I want to show you what has been... I want to show you what has been marked as Defense Exhibit 12. First of all, are these done from the same document?
Yes.
Okay, but there are a couple of differences in 12 that are not in 11?
Yes, sir, there are.
Okay, so let me show you what has been marked as Defense Exhibit 12.
No objection.
No?
Admitted.
Okay.
Thank you.
Now, Exhibit 12 adds a pine tree.
Yes.
Exhibit 11 doesn't have it, but does it add it the accurate distance from the palm tree pursuant to measurements?
It appears to be accurate, yes.
Okay, and so presumably they hadn't found the bullet strike at first in the pine tree right away, so presumably that's why it's not there, but it's included in this one.
Yes.
Objection, Your Honor, it's leading in non-response.
Overruled.
Okay. All right. Now, what is item number 7 in these two pictures?
Number 7 is the evidence placard that signifies the location of the .380 pistol.
Okay. And what item exists at number 7?
There's it's a aluminum post, but it's a sign post.
All right. So let me show you. I'm going to want the Elmo on. Let me show you what has been marked as Defense Exhibit 9F.
No objection.
Offer it.
Absolutely admitted.
Okay. So. Okay. So is 9F, generally speaking, a photograph that depicts, absent the shell casings, what is shown in Exhibit, what was it, 11? 12, Exhibit 12.
Yes.
Okay, so. The pine tree and the palm tree are shown in this exhibit?
Yes.
Okay, and are the palm tree and the pine tree shown in this?
Yes.
Okay, and you've drawn an arrow to the pine tree?
Yes, sir.
Ultimately, that tree was cut down, but at this point, it wasn't yet cut down.
That's correct.
And is this the palm tree that you're talking about?
Yes, sir.
Okay. Now, I want to ask you, do you object?
I'm good with all.
Okay. Offer 9A.
Admitted.
This is a little bit more of a close-up of the palm tree and the signpost,
Yes,
correct? And the firearm was found down here, number 7?
yes, number 7.
See it? Okay.
Yes,
But that's the firearm that was found there.
yes.
Okay. And let me ask you whether or not there is a concrete pad at the base of that,
There is concrete and some asphalt, yes.
okay, at the base of that signpost. Now, was there a bullet strike into the palm tree that you've identified?
Yes,
Okay, let me show you. I'll offer 9C and I'll offer 9E. Let me show you what has been, are they in?
Yes, sir.
Okay.
Sorry.
Let me show you what has been offered into evidence as 9C. Is that the bullet strike?
Yes.
In the palm tree?
yes, sir, it is.
So that bullet strike entered into that palm tree there?
Yes,
Okay. Now, there was also a bullet strike in the pine tree, correct?
that's correct.
Let me show you what has been offered into evidence as 9E. Is that a photograph prior to being cut down of the pine tree with the bullet strike?
Yes, sir.
Does the palm tree have fresh sap related to it running down from the hole?
Yes, indicated by that moist area around it and below it.
Okay. And do you recognize that as an indication of sap? Is that from experience?
Yes, and that, it appears on the crime scene photos of that day, and then subsequent, that moisture was gone, so.
And the significance of the fact that there's fresh sap coming out of the palm tree would be what?
It was likely related to one of the bullets striking. It was on the south side of the palm tree. It would have been in the line of fire, and it was at the base of the tree. So those circumstances all fit, and it was documented in the crime scene report.
Documented in the crime scene report. And
Yes.
of course, you weren't involved yet when this all happened.
Correct.
So you rely on what the documentation in the report is, correct?
Yes.
All right. Now, what about the pine tree strike? Is there fresh sap related to that?
There is. You can see it.
And would your answers be the same, basically, that fresh sap would indicate that it had just happened or it had recently happened?
Yes, sir. That location being on the east or the southeast side of the tree.
Now, for any particular reason, did you run a string, for lack of a better word, from the signpost towards the pine tree?
Yes.
Okay. And why did you do that?
It was to determine whether or not the shot that struck the pine tree would have been related to either the first volley of shots or the second volley. And
without, you didn't do a trajectory analysis, you ran a string from the signpost to the pine tree.
correct.
Okay, and I'm going to talk about how you did that when there was no pine tree there anymore. We'll get into that. But why did you run it from the signpost to the pine tree?
Well, the pistol, the .380 pistol, was located at the base, near the base of that post.
And had you reviewed material in which Mr. Raja had said that whatever the point was, he saw something silver fall when he fired the second 3 shots?
Yes.
Okay. So something silver fall, you're just taking it to mean that that would have been the firearm, basically?
Yes.
Okay. But that was based upon the facts that you had reviewed from the police reports and the depositions and everything in the case, correct?
That's correct. That and the photograph showed the pistol was silver.
Okay, so the photograph showed the pistol was silver. The pistol was found at the base of the sign, and Mr. Raja said when he fired the second 3 shots, it was, the pistol fell.
Yes.
Okay, all right. So, did you attempt to recreate the height of the shot that struck the pine tree?
Yes.
And how did you do that without the pine tree being there?
I was able to use one of the photographs that were taken that included a scale. One of the detectives was holding a yellow placard scale, and it had a scale on it. So I was able to determine the height and the width of that scale. So using that as a scale, I was able to scale off on the photograph the height of that bullet hole above the ground, because that measurement wasn't documented in any of the police reports. So that's how I came about that.
I have no objection to any of these, Your Honor.
Great.
9D?
Admitted.
Okay, let me show you what has been admitted into evidence as Exhibit 9D. It actually has 100 photographs taken that day. So what is 9D showing?
It's a photograph of the evidence tech holding that placard next to the tree. Then the bullet hole, location of the bullet hole is in that red circle.
Okay, so the location of the bullet hole is in the red circle, but there's no measurement given of how high off the ground that bullet hole is?
Correct.
Or was? Okay, so tell the ladies and gentlemen of the jury how you figured out, oh, let me just show you another picture. I know you don't, yeah, okay, so 9B.
Admitted.
Let me show you a far away picture of that same thing. What is that depict?
This is an overall photograph again, and it's taken back near the signpost, but in front of it.
Of course you can.
Again, that's just a far away shot of it?
Yes, sir, just showing the relationship between the 2 trees.
All right. Now, let me see if I can find. Okay, showing you, again, 9D. And you're not talking about a trajectory analysis here. You're talking about locations of the various things, the signpost in the tree, et cetera.
Yes.
Okay. Now, showing you what has been admitted into evidence as 9D. How were you able to determine the height off the ground of the bullet strike?
Again, this yellow evidence placard, the one that's number 2.
So they're not seeing you pointing to it, but I'll point to it, okay? I'll point to it. So number 2.
Yes. It was determined that placard is 3 inches in height. So then using...
Placard itself is 3 inches? That's
Yes.
number 2?
Yes.
Okay.
So using that as a scale, I was able to take 3-inch increments, or the width of that, the height of that in the photograph, and just mark it on down, and then add up how many 3 inches I've got, and I came up with 39 inches. And then that's not an exact, I mean, it may be plus or minus 1 or 2 inches, but there's an error there. But basically, it's about 39 inches above the ground.
So that's, what you did was, that was the only thing that you knew was the size of any particular
Yes.
thing. So you took 3 inches and just figured out how many 3-inch pieces would fit in it.
Yes.
Okay, so you determined that it was 39 inches, give or take.
Yes.
What do you want to say is the margin of error?
Maybe 1 or 2 inches either way.
Okay, all right, so let's say 38, 37 to 42, something?
41, yes. Yeah.
Okay, now, why were you interested in that? In other words, why did you ultimately strung a pink string, and we're going to show it, but why'd you do that?
Again, to visualize whether or not the location of the pistol and the bullet hole in that pine tree would match up or would be related, more relative to the first series of shots or the second series of shots. And what we determined is it was most likely associated with the second volley fire, cartridge cases 4, 5, and 6.
Okay, so probably gonna bore you with a bunch of photographs of the string that you strung. But by the time you got there, that tree was no longer there to attach it to, correct?
Yes.
So on that side, on the tree side, what did you attach it to, and how did you assure that it was 39 inches above the ground?
There's a chain link fence behind the tree.
Is that shown in that picture?
You can see it, yes, barely on the other side of those hedges.
Okay.
And basically, I anchored the string to that fence, and then I came across the center of the pine tree, measured the string at 39 inches above the tree, signifying the level of the hole.
And then where did you anchor the other side of the string to?
I anchored that to the signpost.
Okay, so again, showing you what's been introduced into evidence as 9B, does this show, let me just see, this doesn't show it. Does 9A show the signpost?
Yes.
Okay, and again, showing the signpost and the tree on Exhibit 12, is that? On Exhibit 12, let me mark it for you, but on Exhibit 12, the chain link fence was somewhere behind the tree.
That's correct.
Was it a demarcation with the hotel parking lot? Is that what?
It was.
Okay, and you tied it to the signpost and you tied it to the chain link fence so that the pink string was 39 inches above the ground and centered on the stump.
That's correct.
Okay. Which had clearly been cut down by that point.
Yes.
All right. And why were you interested in determining that? And again, I know you didn't do a trajectory analysis, a scientific thing, but why were you interested in determining that?
It was to be able to visualize whether or not that bullet path from the pistol to the pine tree would be associated with the second set of cartridge cases, numbers 4, 5, and 6. Could be associated, yes.
Okay, and I think you've already said that you placed the pistol somewhere in this general broad area, correct?
Raj's pistol, yes.
Yeah, and the pistol that they found? The
Yes.
pistol that they found was
Yes.
at the base of the tree?
Yes, sir.
And that's the same tree, the base of the sign? And
That's correct.
the same sign that has the concrete pad?
Yes.
And you strung it out to that?
Yes.
And do the photographs of the pink string generally line up to what you said they would line up to?
Yes, sir, they do.
Okay, so let me show you a bunch of photos. And by the way, did you measure the heights from the ground that string would be at various points along its route from the signpost all the way to the tree and then tied to the fence?
I did.
Okay. So in other words, you measured it down into the swale also
Yes.
as to the heights?
Yes.
Okay. And I believe that some of your photographs show you measuring that, right?
Yes, sir.
Okay. So I would offer into evidence Defendant's Exhibit 10F through, well, let me just mention them exactly so that we have the numbers. Well, I think 10A and B are 10A through 10T. Okay?
A through T as in Tom? Okay,
No objection.
all right.
Okay, so I'm gonna try to, people's eyes don't glance over here. I'm gonna try to show you pictures that memorialize what you did. Showing you what has been marked as NG. What are we seeing in this picture?
This would be showing the signpost and this pink line. Of course, it's blurry in the foreground, but then it goes out to the background. But that's just documenting the string and where I attached it to the post.
So this is at the off-ramp side of the picture, the off-ramp side, and showing it tied to the post.
Correct. Just basically, it's on the north side of the post looking to the south.
Okay. Now, let me show you what is in evidence now as 10H. What does that show?
Again, this is the signpost in the background. It's north looking to the south, and again, it's showing the string over the ditch. It's just a farther away view.
Is that what you're talking about here?
Yes.
The view going up to here?
Yes.
And that's south, that's PGA Boulevard,
Yes.
and that's the signpost.
Yes, sir.
Correct.
Yes, sir.
And this is the area where the placard number 7 is, where the silver firearm is.
That's correct.
Now, I'm going to introduce into evidence exhibits 10M and 10L, okay? I think they're all in, but let me just refer to 10L. What are you doing here?
I'm just measuring the height of the trajectory, or call it trajectory line, but the height of that string above the ground at that location.
And it's already attached, is it not, to the fence, the chain link fence on the other side, and already centered over the tree? Over
Yes.
the pine tree?
Yes.
stump? Okay. And again, in 10M?
Same thing.
What's going on there?
Again, just documenting the height.
Okay. And by the way, the reason you documented the height down into the swale was what?
Well, to document if the individual had been in the bottom of the ditch at the time that shot was fired and it went over, where would it be?
Sustained. Rephrase the question for me.
Do it in a more general,
Okay.
you did
Just
it to document.
Where the height of that string would have been above the middle of the ditch.
Okay, all right. Is that just another measurement that you took along the route?
Yes, it is.
Okay, and it shows the pink string on its way to the signpost?
Yes.
Okay. And 10Q, same thing, just a close-up?
Yes.
Now, did you take photographs and measurements relating to as it crossed the tree? In other words, as it crossed the stump of the pine tree, did you take photographs and measurements there too?
Yes.
Okay. So, showing you what has been marked as, what has it been introduced into evidence as 10J. What does this show?
Showing the height of the string above the pine tree, the measurement 39 inches.
So that relates to your ability to take the 3-inch placard and multiply it out and determine that the height of the the entry into the tree was 39 inches,
Yes,
and this shows what 39 inches, where it is in the scheme of things?
that's correct.
Okay. And 10K, again, that shows the same thing?
Same thing, it's just a little wider angle view.
And 10I, same thing?
Yes.
Showing you 10D, at what point were you measuring this?
This was close to this is down towards the bottom of the ditch.
And we've referred to it as a swale, but that's what you're
Yes.
talking about, right?
Yes.
Okay, and what is that height there?
This is 6 feet, 1 inch, 73 inches.
Okay. Now, coming back towards the pine tree, and I would like to show you what's been offered into evidence as 10F. What does 10F show?
This is basically at the level of the string, maybe a little bit below, and again, it's looking towards the pine tree and where the string is anchored at the fence behind. It's just showing the path of the string.
So that shows the height of 39 inches,
Yes,
and it shows where it's anchored behind it?
yes.
Okay. And again, the 39 inches that you're talking about was your best estimate based on the height of the gentleman there in the placard that he was holding to that bullet hole.
That's correct.
And you mentioned that there was fresh sap at the palm tree. First of all, let me ask you whether in your experience you're able to determine, forgetting about the sap for a second, but whether you're able to determine anything about that indentation into the tree, whether it was recent or whether it was old, et cetera.
Well, the defect appears to be fresh. It doesn't appear to have hardened or altered itself in appearance, the size of a bullet defect or bullet strike. So those two in itself, and that it being on the south side of the palm tree, all were relative to one another.
Being on the south side of what? You said the palm tree, but it is the palm tree.
The palm tree, yes.
You mean being on the south side of the tree itself?
Yes,
Those have all concluded in your mind that was a bullet strike?
yes,
Okay. And in addition, there was fresh sap?
yes.
Well, one more. I think 10B is in evidence. If it's not, I don't.
Admitted.
What were you doing in that picture?
I was documenting north with in relation to the stump.
Okay. All right. Now, I'd like you to tell us whether or not in your review of all of the forensic data that was provided, in other words, the crime scene work done by the sheriff and the police, the FBI and so forth, was there a search for blood done?
Not specific, no.
Okay. Now, how do you search for blood, whether it be a huge amount of blood or a little amount of blood or droplets?
Well, it's going to depend on the circumstances of the scene. In this instance, you're probably not going to have a terrible amount of blood based on the circumstances and what took place. So just shining the flashlight and walking around and looking for it with the surfaces that you're dealing with, the asphalt, which it's in the dark, there's ambient light, but it's a different color light. Then you got grass. it's going to be very difficult to see because basically if there is blood present, it's going to be very minute traces. It's going to be drops or just small. And you're not going to be able to really see that by walking around and shining a flashlight. So you may need to use a more specific search procedure, which would be an alternate light source.
And what does that mean, an alternate light source?
Well, an alternate light, it gets its name because originally scientists developed lasers. Lasers were monochromatic, which means they only had one frequency of light, and they were difficult to take to a crime scene. So they developed an alternate light source which emits visible light in the different spectrums. Different materials react differently to light. Hairs and fibers some of them will luminesce. Fingerprints will luminesce sometimes. With blood doesn't emit light. Blood absorbs it, it turns dark. So you would start your search with, and it has a pure white light. So you would start your search with a white light, and then you work through the frequencies. Basically around 425 nanometers is where blood absorbs, it turns dark. So it makes it visible to you, but it's a search that you would have to do basically on your hands and knees. You have to be very close to the surface when you're searching for blood.
And have you done just that on many occasions?
I have.
What would you say? How many occasions?
Hundreds. We received an alternate light source with the sheriff's office in 1993, and I used it until my retirement, so I would use it numerous times.
And does the search for blood need to be done at night?
It's best at night. That's not always possible, and if you do it during the daytime, you're going to have to shade the area so you can provide contrast. Generally, what we would do is we'd put up a tent, and then you'd have to wrap it in black plastic so you can create a darkened environment, and then you would search those areas and then work along the path or whatever the circumstances might be.
And was that done in this case?
No.
And why would you search for blood? Why would you care?
Well, because it's a part of the story. It's a part of the puzzle. You're trying to assemble all these pieces to see what happened. I would want to find where blood started. We have the first 3 volley of shots. Was any blood dropped in that location? And if so, it may be limited as to what I can find out. If it's just dripped blood, I may be able to tell the size and where it came from. I may be able to tell direction. But if you have a drop of blood, that would indicate that likely the blood started either at that location or slightly before it started to hit the ground. So those are the things that you would want to find out there. Even more critical would be back by the signpost, which there was information that there could have been more blood at that location. So again.
Well, assuming that you take into account Mr. Rajasori, that the place where he fell, that he fell and a silver object dropped.
Right.
The silver object is by the pole, we know that.
Yes.
Would that be an area you'd want to search?
Especially in that area, because if the subject fell and he was bleeding prior to getting to that post, then you would be looking for blood transfer. You would be swipe marks, basically. Depending on where the injuries were, there might be dripped blood, there may be impact spatter, or there may be transferred blood. But those are very, very difficult to find in these circumstances. So again, you would have to have some aid. An alternate light source would be the first thing. If you can't find it, then you could go to chemicals if you needed to, but that would be the procedure. And you'd want to rule out whether or not blood is present or it wasn't. Either it is or it isn't.
And if it's not done right at the beginning, what happens to it?
Well, if the scene is not disturbed, I mean, the blood's going to dry. It's going to stay there for a while, of course, until they cut the grass or something, or it rains, it could wash it away. But once it dries, it's going to be fairly fixed. But again, you're talking about quantity. You don't know that. You would want to do it as soon as possible after the incident. Of course, the more time that goes by, you can get degraded if you need to take DNA and that kind of stuff. So it's imperative that really you do it immediately, that you can secure the scene and get in there and look.
And was it done at all?
No, sir, it wasn't.
Even not immediately?
No.
Okay. And tell me again why you need to do it in a tent or in an enclosed area if it's done during the daytime.
It's because you want to make a contrast. You want to provide a contrast between the background and what you're looking for. And with all the ambient light, if you're doing it in direct sunlight, it just makes it more difficult to see.
Now, you mentioned the concrete pad, which is associated with the sign there.
Yes,
And did you note that there was an abrasion on Mr. Jones's arm?
yes,
That was noted in the autopsy report.
yes.
Okay. Did you measure the swell down in this area? Did you measure how much below the surface of the roadway the swell was?
I don't know the elevation. You talking about the string or just the elevation below the roadway?
Yeah, the elevation below the road.
I don't know. It was probably maybe 3-4 feet below the roadway. I don't know the exact elevation.
But you observed clearly that it was below the level of the roadway?
Yes, sir.
Your indulgence. Only two little things that I forgot. And why couldn't you, by the time you got involved, do the tent search or do the light search?
By that time, any evidence that would have been there would most likely have been eradicated.
Was this like this was about a year after?
Yes.
After the incident?
Yes.
And was a bullet fragment ever found that was associated to the palm tree?
No.
Does that happen sometimes? You just can't locate it?
Sometimes.
I have no further questions. Thank you.
Okay. Cross-examination.
Yes, Your Honor.
Thank you, ma'am.
Good morning, sir.
Morning.
Sir, you testified to your history of law enforcement, correct?
Yes.
And you have about 30 years as a law enforcement officer and crime scene investigator combined, is that right?
Yes.
First 15 as a road deputy, last 15 working specifically with crime scene?
Yes.
In both of those roles, you wrote detailed reports of your findings and of the evidence and of what you witnessed, correct?
That's correct.
And did you bring your reports with you today, sir?
I brought some notes, yes.
You never wrote a report in this case, did you, sir?
I didn't know.
If you had written a report, you would have had to turn that over to me, wouldn't you, sir?
Yes.
But you did get every single report provided to you by every witness of the state, including crime scene investigators, FBI evidence response team, our trajectory expert, all the other experts, is that right?
Yes.
But you provided nothing as in relation to a report.
Well, Knox and Associates provided the information and I didn't.
And you're employed by Knox and Associates, correct?
Yes.
Your company, including you, were hired by the defense, is that right?
Yes.
When were you hired, sir?
In this case,
Yes, sir.
I believe we were retained,
Approximate is fine. I'm not trying to hold you to a specific date.
may have been August or September, I think maybe of 2016.
And since that time, your company, including you, have worked on this case, correct?
Yes.
Put in many, many hours, I take it, sir. Is that right?
We put in some hours, yes.
How much do you charge per hour, sir?
I don't charge, I'm salaried, so I don't have anything to do with the charging with the hours.
How much is charged for your time per hour?
You'd have to ask the business people about that.
I'm sure that you're very well aware, sir, of how much gets charged for your time. It's been discussed before. Just how much does your company charge for your time, sir?
For my time, it's $250.
So you do know exactly how much you get charged for your time, sir?
$250.
$250 per hour?
Yes.
How many hours do you believe that you've put into this case? Not your company, because that's obviously a lot more, but just you.
Over, let's see, maybe 100 hours.
Does that include all the travel time of going out to the crime scene? Does it include that?
Probably.
Does it include your travel time and testifying here today?
Well, no, that's would be in addition, talking about prior to.
Would it include your travel and also preparation and any testimony you've provided previously, like depositions?
Probable.
Would it, and you reviewed all the reports in this case, correct?
All of the relevant reports, yes.
And still you think that 100 hours might be a little skinny? Maybe it's a little bit more?
I don't think so. I don't know. I can't tell you. That's a fairly decent estimate.
Okay. Even if we're sitting at 100 hours, sir, at $250 an hour, correct me if my math is correct, that would be just you, not your entire company that was employed, but just you, $25,000. Is that right?
That's what the math is, yes.
Okay. And so $25,000 for you to come and testify to this jury and be a part of this case.
Yes.
And I know that there was, let's get into some of this testimony that you just provided. You stated that you're aware of an abrasion to Mr. Corey Jones's arm. Is that correct?
Yes.
Is that on the same arm that had a bullet hole created by the defendant firing his gun and a bullet from that gun striking Mr. Jones?
It was on the right arm. Yes.
Mr. Jones had a bullet hole in his right arm caused by the defendant, correct?
Yes.
Okay. He had one in his left arm too, didn't he, sir?
Yes.
And those create blood, right?
Yes.
And you said that there was, I believe what you said was there was no search for blood. Is that right?
That's correct. No, I said no specific search for blood.
Very good. And I appreciate you qualifying that because you reviewed all the crime scene investigators' report. You're aware that there was a search for blood, just not in the specific manner which you've explained to the jury. Isn't that right?
Well, the report said there was a search with a flashlight and metal detector. It didn't say anything about blood, just a search with a flashlight.
And so if crime scene investigators got up here and testified that they actually used flashlights and, they obviously did look for blood trails.
Objection, Your Honor.
Sustained. Rephrase.
I'm sorry, I didn't hear you.
Sustained. Rephrase the
So
question.
what you're saying is that there was no specific search for blood in the manner in which you detailed to the jury. Is that right?
That's correct.
And there absolutely was blood found on the scene, though, correct?
There was blood, yes, where Mr. Jones came to rest, yes.
There's blood all over Corey Jones, correct?
Yes,
Blood all underneath him and right close by him. Isn't that right?
that's correct.
Actually, blood all over the defendant's hands from handling Mr. Jones. Isn't that right?
Yes,
And while the blood may show a path, the blood's existence itself doesn't show when it actually came to rest wherever it is, right?
you'll have to say that again. I don't understand what you're saying.
Yeah, I'll break it down. We know that Corey Jones was running away from his vehicle and died by a tree a couple hundred feet away, correct?
Yes,
We relatively know what path Mr. Jones took, correct?
I don't know what path he took, basically. I mean, the path could have been a zigzag path, it could have been an oval path, it may have been a straight line path, I can't tell you. Blood might be able to tell you if you find it along that path, and you can maybe narrow it down to a path. but I can't specifically say he ran from point A to point B in a straight line.
You absolutely cannot say, and you're not testifying, that you know exactly the path that Corey Jones took, can you?
In general, but not specific.
And while the blood may be in one place, you don't know when exactly that blood showed up there, do you?
When the blood showed up, well, I mean, if you find blood towards the SUV, that would indicate it was early on during the incident.
The blood itself doesn't tell you that, though, does it?
Why wouldn't it? How else did it get there?
You find blood on a bumper, blood is on a bumper, correct?
Correct?
You analyze that blood and you compare it and you find that it actually is somebody specific's blood, right?
You would, yes.
But the existence of that blood on the bumper by itself doesn't tell you exactly when it showed up, does it?
But you would also, if you find blood, you would also document what it looked like, whether or not it's fresh, whether it's dried. If it's been there for a long time, it's going to be dried up and flaky. So you would also record what it looks like. That would give you an idea of when it was deposited.
But you're not even coming close to trying to tell this jury that in an event that took less than 30 seconds, the mere existence of blood on one place, you can say it happened exactly at this second of the interaction.
No, I said that the presence of blood wouldn't tell you that it occurred right there. That with relation to these gunshot wounds, it may be a short period of time before blood starts to fall. So all you can say is that the blood dropped here. It could have started, the bloodletting could have started prior to that location, but this is where it hit the ground. Again, it's just another piece of the story, and you need to see how it fits together with the overall physical evidence.
And out of all of this entire huge investigation with all of these people, the one thing you have to say is you could have done a little bit better looking for blood. Is that what you're saying, Judge?
Overruled. Can
Is that
answer.
what you're saying, sir?
It could have been done better, yes.
Doesn't mean that anything would have ever been found, does it?
You don't know that unless you find it or you search for it.
But doesn't mean that anything would have ever been found or that it would have been really changing anything at all, would it?
You don't know that. Nobody knows that.
Let's talk about your casing ejection test, sir. How exactly did you perform that?
We used 3 Glock 27 pistols using similar ammunition, and we went to a range in Jacksonville out at the old Navy base, and we reconstructed it on asphalt. This scene, again, is asphalt, so we used asphalt. And we fired 20 rounds from each pistol and then documented where each one of those cartridge cases came to rest, and use that to compare to the location of these cartridge cases at the scene.
And what was the ammunition that you used, sir?
It would have been 40 Smith & Wesson. I don't have the notes on the exact ammunition, but we used the same grain ammunition.
But you don't know if you used the same weight, whether the grains that were involved, or obviously not the same exact ammunition, correct?
It would have been as close as we could get. Mike Knox is the one that would have purchased that and researched that and used it, so he got all that together. I can't tell you right now but it was as close as we could get to the actual ammunition.
Did you fire the weapon, or did Mr. Knox fire the weapons, plural?
I fired the weapon.
Did you use a tripod, sir?
No.
So you used just a regular shooting stance with a 90-degree vertical holding position, is that correct?
My shooting stance was this way
Gotcha.
for each shot.
And no stable tripod or any type of stable place to put that firearm whenever you shot it, sir?
No, we used a 0 point, which means I held the pistol directly over 0 and at the level that we estimated the muzzle height to be,
What was that level, sir?
about 5 feet 5 inches.
And when you say you held the pistol over the 0 of the point, you talking about the ejection port, the handle, or the actual?
The ejection port.
And did you use an actual graph? Did you graph it out so that you could have your x-axis and your y-axis and your quadrants and
Yes.
all your measurements?
Yes.
And you measured to the spot that it actually landed and came to final rest, where it landed initially or where it came to final rest?
We measured where it came to final rest.
And did you incorporate any type of error into your measurements?
Mike Knox probably did. He's the one that did all the scientific data
So you're not the one that did any of the numbers associated with it?
Correct.
So you're not going to be able to come here and say, the casings came to rest on an average of this far to the right and this far behind the shooter with a plus or minus error of any number. You can't do that right now, can you?
I can't, but I can tell you what I remember where their location was.
And what you testified to is that it's to the right and behind the shooter, correct?
Correct. Basically, that's where they eject to. That's not necessarily where they end up at final rest, but yes.
They ended up to the right and behind the shooter, correct?
Not all of them. Some were straight off to my right.
How many shots straight off to your right?
Several, probably with each pistol, maybe 3, 4, 5.
And is that why you're supposed to build in this error and you account for ones that may shoot off to the right and then also consistently look where most of them end up? Is that correct?
Yes?
But you don't know what those numbers are, do you?
No?
Because that's not what you're testifying about.
Correct.
And what you testified to is that you expect the casings actually to go to the right and behind the shooter. Isn't that right?
I can tell you that the 3 tests that we did with the 3 pistols, the locations were all consistent with each other, and we used that information with regards to the locations of these cartridge cases.
To the right and behind.
Yes?
Yes. And you said you did this test on asphalt. Is that correct?
Yes?
Obviously not the same asphalt of the exit ramp. You did it at a shooting range in a controlled environment, right?
Yes?
So you're not trying to say that exactly the way that that asphalt is worn or anything related to that is exactly the surface that you conducted your testing on, right?
Just same surface.
And I take it that the surface, because you're shooting a gun, you take it that it's a level surface, is that right?
Relatively level, yes.
So you're not taking into account anything dealing with the slope of the exit ramp coming off I-95, correct?
Correct.
And if you were to take that into account, obviously, since you're looking at where a casing ends up, if you're shooting on a slope, you would expect that there is a potential that the casing would roll in the direction of the downward slope, correct?
Depending on the degree of the slope, it's possible.
But you didn't account for that at all in the testing that you did.
I can't tell you what Mr. Knox included in his calculations.
And you're familiar with all the measurements from the Leica from Palm Beach County Sheriff's Office?
Yes?
No disagreement with those measurements?
No?
You're familiar with the measurements of the left-right tire of the SUV? And I know you said it was a black SUV, but it wasn't a black SUV, right?
May have been gray.
Do you know what color it was?
I don't recall it exactly offhand. It's dark colored.
Okay. It looks black on this picture here, but you're not saying that's actually what the color was,
No.
correct?
No.
Okay. So when we're looking at the measurement of the casings to the left rear tire of this SUV, and if you don't have it, I mean, I can provide it to you, but the Leica measurements are casing number 1 to the left rear tire is 6 foot 4 inches, casing 2, 12 foot 10 inches, and casing 3, 17 foot 5 inches. Does that sound accurate?
Yes?
And so we agree that the defendant was expected to be firing to the northwest, is that correct?
Yes?
And so we expect then, minus any obstructions, of course, that those casings are going to end up behind and to the right of them, like you said, correct?
Yes?
And so now, when he's firing, he's actually going to be firing in a position that's away from the casings, and even when we get to casing 3, further away from the SUV, correct?
That's where it ended up, yes.
And so when he's firing casing 3, obviously he's further away than where casing 1 is located.
You're talking about the casing is further away or Raj is closer? Not necessarily, no.
So you stated previously you thought that the defendant was at least 10 feet away in the back of the SUV when the first round of shots were fired, correct?
I'm sorry, again,
That the defendant was at least 10 feet behind the SUV when the first round of shots were fired?
I think I intimated probably maybe 5 to 10 feet, something like that.
And that's from your estimate, from where you believe the casings ended up, and a general idea of him being forward and to the left of those casings, correct?
Correct.
But you didn't bring any specific measurements, that's just what you're saying generally today?
Generally, yes.
Even with your approach, you're putting the defendant 10 feet behind this SUV before he fires the first 3 shots against Corey Jones, isn't that right?
Well, I said 5 to 10 feet, but again, this is where they ended up. This is the generalization, somewhere behind. Obviously, they're behind the vehicle. The distance behind, you really can't tell because you don't know how those cartridge cases end up. All you know, are ejected and how they tumbled. So basically, all you have to go by is their location. So generally, 5 to 10 feet, possibly behind the vehicle.
Possibly more.
Maybe.
I mean, you didn't account for the slope of the ramp, correct?
There wasn't a whole lot of slope.
But you didn't account for it, did you?
Again, I don't know what Mr. Knox would
You
have
can't
accounted
say
for.
Whether or not it could be more than 10 feet. You really can't say.
I can't say.
And that's fair. Shots 4, 5, and 6, once again, we know that they end up to the right and behind the shooter, correct?
Yes?
He's now shooting in more of a northerly, northwestern direction again, correct?
Yes.
According to you, this would place the defendant, the shooter, closer to this guardrail, correct?
Not necessarily. It would be on the guardrail side, close to the edge of that outside lane. But just to go back, when I talked about the cartridge case ejection test, not all of the cartridge cases, when they terminated, when they came to rest, were behind me. So again, you have that X and that Y coordinate. Some of them were straight out to 90 degree. So looking at that, that doesn't mean that all of the cartridge cases were behind him, putting the shooter farther up. So the ones that you have farthest up could have been off directly to the right. So again, it's a generalization.
And that's why when you do this test, you build in this error in these averages so that you encompass what you expect really all the casings to fall within. Isn't that right?
That's correct.
But you don't have those numbers, and you don't know them, do you?
I don't.
So what your testimony is, even though you say that some of these casings ejected, you really don't know what the numbers are as far as how many feet to the right, how many feet to the back. We expect any casing within a degree of certainty to end up, correct?
I can give you an estimation of what I recall from the testing.
From what somebody else did.
Well, I observed where the cartridge cases ended up.
And so if we're doing the general testimony, because that's really what you're providing, of to the right and to the back, and this shooter, the defendant, is shooting in a northwesterly direction, then we naturally expect him to be to the left of the casings, correct?
Yes?
And that would place him closer to the guardrail, correct?
Yeah, in that,
It's not a trick question, sir.
no, I'm just, the shoulder could be between the outside lane and right there at the shoulder, so somewhere in that location.
So closer to the guardrail.
Yes.
And obviously, here's a picture right here showing how close this pole is to the guardrail, correct?
Yes?
Did you measure the distance between the guardrail and the post, sir?
I didn't, no.
Generally, because that's what we're talking about mainly, say that's very close, correct?
Probably within a few feet,
Maybe even closer.
possible.
And when we look at here where you have this tree put, that's not to scale by any means, is it, sir?
I have no idea. I didn't draw that.
You did not draw this.
No. But it says not to scale, so I'm assuming that's not to scale.
But, and actually, this wasn't introduced by a crime scene investigator. This was introduced through you today. So who
Well-
put that tree there?
I didn't. I don't know who put the tree there. I have no idea.
Did your company put the tree there?
No, not that I'm aware of.
Did the defense put the tree there?
I don't know who put the tree there.
So this, obviously, you have zero idea whatsoever of the relationship of this tree to any other object in this diagram as being accurate whatsoever.
It's in proper relation, but no.
In kind of general, we all know, by looking at that palm tree, we know that the pine tree was to the west, maybe a little south of it, right?
That's correct.
But this definitely is not specifically to scale whatsoever, and you didn't put it there.
Correct.
So you're aware, though, where the defendant placed Corey Jones during his second volley of shots, correct?
Yes.
And it's actually denoted right here with these cones on this diagram that we're looking at, correct?
Yes.
And where the defendant says that Corey Jones was during that second volley of shots also falls in line with that tree. Isn't that right?
It could, yes.
And so, and we're going to get to this string. We'll get to it right now. So even though you hooked a string to a point on that fence and then to this post right here, doesn't mean that Mr. Jones couldn't have been over here where the defendant placed him, correct? During that second volley of shots.
Correct.
And when we talk about that string to that post, let's be real clear about what that represents. It represents literally a string that you tied to the fence at a place to where it would cross the tree and you could tie it to that pole, correct?
Yes.
Okay. And you use this pole specifically because you knew where the gun was found, correct?
Correct. That and the location of the cartridge cases, yes.
Now, you absolutely are not testifying as a trajectory expert at all, are you?
No.
You're not trying in any way whatsoever to tell this jury that you intend for them to take this as some type of trajectory, are you?
No.
Because you didn't present anything about a trajectory cone with built-in error, did you?
No.
You didn't say anything about any type of methodology or experience and training, everything that you would have to ever come before this jury and say this is a trajectory, isn't that right?
Correct.
So we're clear. You put it up to this post because you believe there is a gun there, right?
I didn't believe there was a gun. It was documented there.
And you put it there because of the statement of the defendant, right?
That and to visualize, if the string is there to visualize and to see if it was in relationship with those cartridge cases and the pistol.
Did you ever review all the total station data from the FBI, sir?
I didn't.
You ever heard of contextual bias?
I've heard the word. I couldn't tell you what it means.
Okay. If I told you that it meant, getting biased because of learning about information from the scene before actually making some type of scientific determination, that kind of fit into what you think it is?
Kind of like confirmation bias.
You could have hooked that piece of string to a lot of different places on that fence and crossed that tree, right?
Sure.
Because really we're using this tree as that fixed point in which to cross the string over, correct?
But we know that's where the bullet struck. Yes.
So we could have taken a string and put it maybe a little bit northerly on that fence, cross the same tree, and then come up south of that post closer to like Mr. Jones' SUV. Could have done that, correct?
It may be possible.
How about, definitely. I mean, all you're doing is placing a string to make it go over a fixed point. I mean, you literally could place that string 360 degrees going around in a circle on this post, and as long as you're hitting it 2 different points off in space, you're gonna cross that tree, right?
Yes.
So you absolutely, definitely, not possibly, but you definitely could find a place on that fence to hook that string and go over the tree and connect it to where Corey Jones' SUV would be.
Considering there wouldn't be any other intermediary objects between that pine tree and the SUV. So, I mean, yeah, it could be done. Whether or not there's anything there, I don't know.
So the actual answer is yes.
Could be.
That's also in a southeasterly direction, correct?
Yes.
But by you saying that the bullet that struck that pine tree is from the second volley of shots, that helps out the defendant, doesn't it? It matches more with his story, doesn't it?
That's not my concern. My concern is to figure out, based on the physical evidence, what's most likely. And most likely was it's associated with the second volley. That's all I'm looking at.
But my question was, by saying that, that actually helps out the defendant, doesn't it?
It may.
Because it's more in line with his version, isn't it?
Well, it's supported by the testimonial evidence, yes.
And you used his statement in your analysis, as you've previously stated, correct?
Yes.
But you're aware that his statement has many inconsistencies between it and the physical evidence, correct?
Yes. Not unusual, but yes.
And so, even though his statement has many inconsistencies with the physical evidence, you still used it as part of your basis in the testimony that you have here today, isn't that right?
Yes.
And you agree that some of those inconsistencies, I don't want to belabor every one of them, but some of those are absolutely inconsistent where the defendant placed himself initially and where the first volley of shots, by your understanding of the casings, were. Totally different, right?
Yes. Again, but not unheard of.
And I'm not asking what you heard. I'm just trying to make sure that we understand. They're totally different based on the physical evidence, right?
Yes.
There's even a difference between where the defendant places himself in the second volley of shots, isn't there?
Yes.
There's a difference between what the defendant says in relation to when he calls 911 and when he actually calls 911, isn't that right?
Yes.
There's a difference in the length of time that the defendant actually places for the entire shooting to take place and the actual length of time that we know for sure. Isn't that right?
Yes.
However, you still use that statement as part of your testimony here today, isn't that right?
Yes.
But you agree that the evidence supports that the defendant was pursuing Corey Jones away from his SUV before the first shots were fired, correct?
Pursuing or following, moving in the same direction,
Chasing?
whatever term you want to give it, but they were both moving in the same direction, basically.
Let's use that term, chasing. So we know that Corey Jones is now being chased further behind his SUV than where the defendant was when those first round of shots were, correct?
Moved away, yes.
And while you give your estimate based on everything, including being paid, that the defendant was 5 to 10 feet behind this SUV when he fired those first 3 shots, we know, according to you specifically, that Corey Jones was even further, correct?
He would have been, yes.
No, not might have been.
I didn't say it might have been. I says he would have been.
He would have been. Okay, very good. Thank you. And you estimate that Corey Jones was at least 30 feet behind his SUV prior to that first shot ever being fired, correct?
Approximation, yes.
approximation, or are you going to say,
Well, according to the testimony, after the first 3 shots, Mr. Jones then turned and ran around the end of the guardrail and ran up alongside of the guardrail. So with that statement, obviously he was before the guardrail at some point
stick with about 30 feet?
about that.
So Corey Jones is, in your estimate, 30 feet behind his own vehicle at the time that the defendant fires that first shot at him.
Possible. I mean, it could have been a little bit closer.
Could have been a
Could have
little
been a
bit
little farther. Yeah, but nobody knows.
Well, somebody does know. That's not accurate, is it? Somebody does know. Right?
Well, yeah.
Okay.
It's
Could have
fired.
been a little bit less than 30 feet, could have been a little bit more 30 feet that Corey Jones was at, right?
Yes,
Out in the open with no cover around him, correct?
presumably, yes.
And that's the time that the defendant fires that first shot, is that right?
Your Honor, object to outside the scope.
Overruled.
And that's the time that that defendant fires his first shot, is that correct, sir?
That's the time when.
When the defendant fires that first shot from his gun at Corey Jones, sir, when they're behind the vehicle at those distances.
That's correct.
And this is not just some firing, you see by the casings that there's still movement occurring as that gun is being fired. Would you agree with that?
No, there's movement of the gun, is that what you're saying?
That
Not
it's
necessarily.
like the gun's just sitting still and the defendant's just standing there. There's actually a progression of casings. I mean, we got the distances from 6 foot to 17 foot.
I understand, but that doesn't mean the cartridge, that Roger was moving as he's firing. That doesn't indicate that at all.
Because, wouldn't you base that, though, off of the average distances that those casings could roll as part
No.
of rejection testing?
No, the first 3 shots were fired off. There's the first shot, there was a small pause, and then the next 2 were in quick succession. But again, during our cartridge case ejection test, all of the cartridge cases don't come to rest in the same spot. They bounce around. So you can't say, based on the locations of those 3, that there was movement as the shots were fired. They could have all been fired from relatively a stationary point.
But you can't say at all because you don't know the numbers of the ejection case testing, do you?
I don't know the numbers. I know where the cartridge cases ended up when I fired.
And you can tell that from 6 foot behind the vehicle to 17 foot behind the vehicle, there's a difference of 11 feet that is heading in a northeasterly direction of those casings, correct?
Correct.
So while you say it's possible that the defendant was standing still when he fired all 3 shots, it's also possible that he continued to pursue Corey Jones, who he was already pursuing. Isn't that right?
I don't think so, not at the time the shots were fired.
And you're basing that off of the location of the casings?
Yes, because where the cartridge cases end up, one of those cartridge cases, if you want to use number 1 as being the one that's closest to the SUV, when it hits the ground, it could have bounced back towards the SUV. It could have been farther up the ramp and then bounced back. The one that's the farthest away, number 3, could have bounced to the right of him and then ended up terminated here. It doesn't mean that necessarily there's movement along that path. Again, all of those shots could have been fired from a stationary point. Does not indicate that he's moving forward.
So you just said that he could have fired a casing that bounced back down the ramp, correct?
Yeah,
All 3 of those casings could have bounced back down the ramp, isn't that right?
they could have, or they
That
could have all
means that-
bounced forward.
And his position could have been even further away, and by his, I mean, the defendant's position could have been even further away from the SUV than what you previously stated, right?
Yeah, but it could also have been closer.
And so, according to the defendant, at the time that he fires his 3rd shot, Corey is running away from the vehicle, right?
Well, after the 3rd shot, he's running away, yes.
And we know that it's 72 feet from the end of the SUV to the firearm. About 72 feet, you agree?
About that, from the left rear tire, I believe, yes.
And according to your testimony, you placed Corey Jones about 30 feet behind the SUV at the time the first shot is fired, correct?
Approximately, yes.
Are you going to state that you would agree that Corey Jones is moving further away from the SUV, maybe even running, during the shot of those 3 shots?
Say it again.
Would you agree that Corey Jones is moving even further away from the SUV, even running, during those first 3 shots?
I don't know that.
You don't know that.
No.
Very possible that somebody would be running away from the person who is shooting a gun at them?
Is it possible? Maybe.
Maybe? Mm-hmm. You don't think it's likely?
No. And you'd have to base it on the gunshot wounds.
Which you're not an expert, are you?
No.
Did you incorporate that into your findings and your testimony here today, sir?
No.
But the defendant says that Corey Jones is running away from him in his statement, doesn't he?
After the third shot, after the first 3 shots, he turned and he was running around. He ran around the end of the guardrail, running north. Correct.
So after that third shot, according to the defendant, which you take as being consistent, Corey is running away from the vehicle even further, correct?
Well, he's moving away.
Okay. Are you saying and testifying that Corey Jones traveled a complete distance of 40 feet at the most in a 10-second period of time?
I can tell you that there was 10 seconds between the third shot and the fourth shot. How long it took him to get to one point or another, I don't know. He could have gone past the post, turned around, and came back towards the post when the time the fourth shot was fired. Nobody knows the path. Nobody knows the path. Well,
But he does know, correct?
probably, if he remembers, but nobody knows the exact path that he took.
We keep saying nobody knows, but we keep coming back that somebody does know. You're saying that you think it's possible that Corey Jones, after being shot at 3 times, ran past this sign and then turned around and came back? That's your testimony?
It's possible.
You agree 10 seconds between the third and fourth shot? I know you already said it, but I'm just making sure that we're clear. 10 seconds between that third and fourth shot.
Yes,
Correct?
there's 10 seconds. 9, 10
According
seconds,
to
yes.
your estimates, 40 feet between where Corey Jones was at the first shot to where his firearm is, correct?
Yes.
And so you're telling this jury that you actually think that Corey Jones ran 40 feet in 10 seconds?
He could have run more than 40 feet.
He could have ran a lot more than 40 feet, right?
Like I said, could have turned around and came back. In the path, I don't know what the path was.
Could have ran a lot more than 40 feet, right?
In 10 seconds? Possible, yeah.
Twice the amount, correct?
Possible.
With somebody who has zero indication that he's law enforcement on firing a gun at him, he could have ran at least 80 feet, couldn't he have?
I don't know.
I've got no further questions at this time, Your Honor.
Redirect. You're welcome.
So counsel suggested that the diagram was not to scale. That was a sheriff's department diagram, right?
Yes,
They prepared it and relied upon it and introduced it into evidence in this case, didn't they?
yes.
Okay. The reason you picked the signpost as opposed to 360 degrees in a circle around it was because the silver object that Mr. Raja told the police had fallen was located at the signpost.
That's correct.
and he told the police that that Mr. Jones had turned at the sign, turned somewhere, and aimed his gun at him again, and he fired 3 more shots, correct?
That's correct.
What your testimony is that you don't know what he did in the interim between the first 3 rounds and the second 3 rounds, but you picked the signpost because it was consistent with the shell casings
Yes,
and the silver object being the handgun, correct?
yes.
And it lined up with the pine tree, correct?
Yes.
You didn't just arbitrarily pick that out of a 360-degree circle.
No.
Would there have been any reason to do anything other than take the statement that Mr. Raja gave under oath, that he had turned, fallen and dropped the silver object right at that area?
No.
Okay. And what you said and you were asked was, did he get it wrong where that had occurred? In other words, where he spun around again, pointed the gun at him, shots were fired, and he dropped the silver object. He had
Objection,
placed
Your
that
Honor.
farther down.
Pause, everybody pause. There's an objection. I didn't hear the full question yet. Let him finish the question, and then don't answer until I've heard the whole question.
The question itself is part of my objection.
All right, then why don't you come on up?
Sure.
Why did you pick the signpost to anchor the pink string to that you ran to the pine tree?
I had to have a stationary object to be able to pull the string tight. There was nothing else out there. So it doesn't mean that, that string was right there. It could have been a little bit to the left. It was just getting an idea, again, to make it visual to me, to the observations based on locations of the cartridge cases, where the pistol was and where the pine tree is.
Okay. So you said it was based upon where the pistol was and where the casings were,
Yes.
correct? Okay. So you didn't arbitrarily pick a spot, did you?
No.
All right. And I think you said generally what as to where the cartridge cases go, generally speaking, it's not an exact science, but generally speaking, where do they go when a shot is fired?
Okay, well, basically, there's 2 parts to it. Where they go, where they eject, when they come out of the ejection port, basically it's to the right and behind. But depending on the surface you're talking about, if it's grass, they may stop right where they hit. But with this case, we're asphalt, so they may, again, when they're coming out, they're tumbling over and over, and they're spinning around. So when they hit the surface, they may go forward from where they landed, they may go backward, they may go farther out to the right. So there's a variation of where they're going to end up. But all of them ended up in that right rear quadrant. Some were behind me when I shot, some were directly off to my right, some were maybe a little bit forward. But so that gives you an idea.
You're not expressing any opinion, are you, as to what Mr. Jones did or didn't do other than relying on the fact that that Officer Raja said a silver object had fallen?
That's correct.
Now, you were asked whether you wrote a report. You turned over a thumb drive, didn't you?
Yes, Mr. Knox did, yes.
And it had all of your work and calculations on it,
It did.
and it was turned over to the state attorney's office?
Yes, that's my understanding.
Your indulgence.
All right, you may step down, sir. Watch your set. Thank you very much. All right, so jurors, my gut reaction was right this morning. So what's happened in the interim is I got some menus waiting for you, and I'm praying it's not Jimmy John's. You need a break. And so we're going to take a break while we get the next witness ready. and we're going to let you go in there, order up your food. We'll order it, and then we're going to go until it's delivered because now we're a little late ordering it. So leave your pads upside down. Don't talk about the case. Get yourself some lunch. Lawyers, get your next witness in the wings, and let's take a 5-minute break while they order, and we'll reconvene in 5 minutes.